Hello and good afternoon, everyone. I hope you are well. The sun is shining where I am, so I hope you have the sun shining on you as well. It's the 11th of July, the date of broadcast. And what I want to do today is obviously just bring you a bit of a post-election special. As you know, I tend to do my webinars at the end of the month, but obviously with the events that happened last week, I thought it was timely to have a look at what may or may not happen with our new government. So for those who don't know me, I'm Emma O'Connor. I am Legal Director here in the employment team at Boyes Turner, and I'm also Head of Client Training. If you don't know Boyes Turner, we are a full service law firm based here in the Thames Valley, but we service clients all across the UK, Europe and globally, assisting clients with commercial aspects, corporate affairs, and in the employment team, we help clients employer clients with day-to-day HR support, litigation, contracts and policies, business immigration, and what I do, HR and manager training. I am live. You will receive a recording of today's webinar and also all of our previous webinars, as well as our podcasts, can be found on our YouTube channel, which I'll also send you details of how you can look and find out. This is the first time that you've joined us. The aim of our webinars is to bring you topical information, things that maybe you haven't thought about already, or just to kind of keep you up to date with what's going on in the world of HR and employment law. I'm not going to be giving any legal advice. This is just an overview, and any political comments that I make are my own. And if we are not already linked in, why the devil not? So please do link in with me. It's a great way for you to keep in touch. Also, I share on my LinkedIn post case law updates, obviously invites to training events, webinars, and give you information about podcasts. So it's a really great way for you to stay in touch with what we're doing as well. And also I'll be sending you information about how you can sign up to our newsletters and our monthly updates. So again, good way to stay in touch with what's going on. What have you missed? Well, you missed the HR Masterclass. Absolutely brilliant this year, fantastic response, great delegates, and it's really great to see so many of the HR Masterclass alumni signing up to our webinars as well, so that's brilliant. If you're interested in running an HR Masterclass for your HR teams, really looking at managing the employee life cycle, but from an HR perspective, then please do get in touch with me. Another really popular course is our Essential Manager course, or a Manager Masterclass. Again, a day-long course, which is really looking at giving managers the tools and the confidence to be able to manage those key areas where we want our managers to be involved in managing absence, performance and conduct. And we also look at being an inclusive leader as well. Other projects I'm involved in at the moment, staff representative training, particularly around collective consultation when we think about redundancies, and also around redundancy procedure and practice more generally, particularly when we think about those changes that we had in April of this year. And also flexible working, again, lots of training around how we can support employees and also managers when they find themselves receiving a flexible working request, which, as we know, is a day one right now. Training can be virtual, it can be in person, also, bite-sized, doesn't have to be a day or half a day. And also we can look at doing, e-learning, pre-recorded training courses as well that you can load onto your LMS or you can roll out to your staff. Next webinar, as I said, tend to do these at the end of the month, and this is a little sort of extra special webinar for you, but my planned webinar for this month is looking at menopause in the workplace, quite topical as well with some things I'm going to be looking at today, and we're going to be focusing on the role of menopause champions and again how we can support our employees, our women in the workplace, who may be experiencing menopause, perimenopause symptoms. So great webinar there. I'm joined by Dean Murray of Menopause Experts, who's a fantastic speaker. So I do encourage all of you to sign up to that webinar at the end of this month. I thought, just sort of looking at today, so as we know, we have a new government. I'm always quite interested in all things political, and I thought this was very interesting. This sort of, vote share was doing the rounds in terms of, how the vote share was last week, and it's quite interesting. I know a lot of commentators were calling it a bit of a Loveless landslide. But there we are, and we do have a new government, a new Labour government. And so let's have a look at what we may see over the next few years. So Labour published, didn't they, back before the election, their plan to make work pay, which was entitled Delivering a New Working Deal for People. And within that document, there were some information there about what it is that they propose to do, particularly looking at the first 100 days of the government being in office. And as well as sort of giving an overview, and it will be an overview, just of some of those key elements that I think we should be thinking about now, and obviously what that might mean moving forward for HR teams, business leaders, but also kind of our employee populations more generally. I also want to have a little look at where we are with current legislation that is due to come into force in the autumn. Because I think we're in a bit of legislation limbo as well. So I just want to look at, what may or may not happen, what should we be doing with regards to those legislation changes that were planned under the previous government. So that's what I'm going to cover off today. So let's have a look at some of the changes. And I think really this is going to be probably the biggest change, if not one of the biggest changes which has been proposed. Now, as we know, when we look at ordinary unfair dismissal, so not looking at those automatic rights that employees have to bring claims for unfair dismissal, so in the ordinary sense, we know, don't we, at the moment, that employees with over 2 years service have that right, that statutory right, not to be unfairly dismissed. And that's really looking at the employer being able to show that it had a potentially fair reason to dismiss. And as we know, under the Employment Rights Act, there are potentially 5 fair reasons for an employer to dismiss an employee: capability, conduct, etc. And also we know that as well as having that fair reason, employers also need to follow a fair process prior to dismissing the employee. Now, the big change and the big proposal here is that this is going to move from having that 2-year length of service to being a day one right. So this is potentially huge, that employees have the right not to be unfairly dismissed. Basically, they don't have to wait 2 years to be able to bring that claim. The fair reasons, and that need to have a fair reason, a fair process, is not going to change. It's just that it's going to be a day one right. So again, this is potentially huge for employers. Quite understandably, there has been some pushback from employers on this, about how potentially unworkable this is. And what Labour have said is that they are going to look at having a carve out for a probationary period. Now, I don't know how long that's going to be. There is no mention of how long that probationary period is going to be. Is it going to be 3 months, 6 months? I doubt it's going to be much longer than 6 months. But again, we don't know. And also, during that probation period, there is going to be an emphasis on employers having a fair and transparent process if they are seeking to end employment during that probation period. So what does that mean? Well, potentially a lot of litigation there, be that employees bringing day one rights to unfair dismissal, but also what does this probationary period look like? What is a fair and transparent process? Are we going to have an ACAS code? Potentially, are we going to go back, for those of you that can remember, the statutory disciplinary process that employers had to be followed, that sort of three-step process that was mandated through legislation. So are we going to go back to that? I think it's going to put huge pressure on managers, particularly around, managing the probationary period, managing the onboarding process. I think it's going to put pressure on the recruitment process, making sure that we get the right person for the job from the start, seeking then to avoid having to then, bring employment to an end. So I think there's going to be huge pressures there. And again, the potential there for litigation. So I think that's going to be one to watch, because I do think it's going to have an impact, and it will change the way, obviously, we will be managing onboarding and also, the termination process during, as soon as somebody starts employment, save for that carve out. So watch this space. The other biggie, if I can call it that, is the proposal to extend the time limit to bring employment tribunal claims. Now, as we know, for the most part, employment tribunal claims have that 3-month window within which employees can bring a claim. Of course, it's not that. We know that that's a 3-month window for them to contact ACAS and to go through early conciliation, because as we know, the clock, that clock stops during the early conciliation period and restarts, obviously, if agreement is not reached between the parties. But there is potentially that 3-month window in which to do that. Again, the proposal is to extend that period of time from 3 to 6 months for all statutory tribunal claims. So unfair dismissal, discrimination, unlawful deduction for wages claims, etc., etc. So again, I can see this having a huge implication for HR and businesses. When we think about it, I can see some sense for claimants having that extra time, particularly around those sort of complex claims. Perhaps they're whistleblowing, having more time to be able to, get ducks in a row before bringing a claim against their employer. I think it might mean more DSARs potentially, because, employees there and workers, as we know, have got a longer time in which to be able to undertake a DSAR. As we know, those take, employers can have up to a month unless it's extended to get that DSAR in time. So we might find actually DSARs becoming, that's data subject access requests. We might see more DSARs, data subject access requests, being made as part of that 6-month window. So watch out for that, please. And then obviously, training around what we write, how we send emails, making sure that we're not, putting things in writing that perhaps we should not be as managers and HR. So yes, potentially some sense there. I think we will see a rise in DSARs. Also things around evidence, if we've got to keep data and information for a lot longer, potential there for claims, what's that going to look like? What does that mean for our retention? Policies for documents, what does it mean for, employees leaving, potentially witnesses leaving, memos fading, documents, maybe not at our disposal anymore. So I think there are some real implications there, again, for employees, but also for businesses as well. So, a big change there we can expect to see, and one to watch. Those of you who are joining me or are listening to this on demand, who are what are termed as larger employers, so those that have over 250 or more employees, would be categorized as a larger employer. And those of you who do fall within that category are used to having to produce your gender pay gap reports in April of this year. However, what we're going to see is an extension of that obligation for our larger employers, not just to produce a gender pay gap report, but also to produce pay gap reports based on the ethnicity of your workforce, and also where you have individuals who are disabled within the meaning of the Equality Act. I can see all sorts of issues around that. Who does one compare oneself to? Are you aware of those individuals within your workplace who have a disability? Remembering again, employees are under no obligation to tell you of their ethnicity and also of any disability as well. So I think there's going to have to be lots of guidance there around what it is that employers are going to be expected to report on and how. Again, an extension there of the equal pay. So at the moment we have sex-based gender pay requirements, equal pay for like work rated as equivalent within a job evaluation scheme or work of equal value. Again, we have that now under the Equality Act. What we're going to see is an extension of that right for individuals to bring claims for equal pay, again, based on ethnicity and disability. Again, I question how that's going to work in practical terms, particularly when we think about the comparator. Who is somebody going to compare themselves to, and how does that work? And again, is that going to be what we see now just within the workplace, within the group? So some questions there around what that is going to look like when we think about equal pay claims. But yes, do expect legislation which is going to be extended and certainly introduced, focusing on the right to bring an equal pay claim in those situations. If we go back to the gender pay gap reporting, there is an aim that employers don't outsource employees with a view to avoiding having to report on what their pay is. So now employers who outsource workers are going to have to include those within their gender pay gap reporting. So again, this is going to make reporting potentially much more onerous on employers, not just the increase there in terms of the scope of the gender pay gap, but also including individuals with a disability and looking at ethnicity pay gap reporting as well. So again, a lot of work there to be done for HR teams. And again, for gender pay gap reporting purposes, employers are going to, who are caught by the rules, are going to have to publish an action plan. Most employers already produce a narrative which explains the journey that they are on with their gender pay gap reporting. But again, this is going to focus much more on what the action plan is going to be. What are you actually going to do, employer, to be able to do it? So again, some questions there. What it means by an outsourced worker, I mean, who knows? But certainly, you know, there is going to be an emphasis there on not just looking at who works for you, but again, who have you outsourced, you know, to third parties, and how does that work with, you know, issues around data and data protection? Can the service provider, do they have the consent to be able to disclose this information? So again, this is going to create a lot of further questions than I think perhaps have been thought about thus far. So watch this space. In terms of how we're supporting clients, we are already supporting clients in producing their gender pay gap reports. And certainly, if you want to talk to us about how we can support with ethnicity and disability pay gap reporting, even if you are not caught by the regulations, we have a number of clients who aren't caught by the 250 plus employee bracket. So, you know, if that's something you're interested in as part of your work towards, you know, supporting equality and inclusion, then again, please do speak to us, and I'll be sending you out details of how you can do that at the end of the webinar. Equality and family rights more generally. The first one there is menopause action plans, and I'll be talking about that a lot more when I run my webinar at the end of this month with Dee Murray, looking at what those menopause action plans are. But again, this is something that is going to be required for those larger employers with 250 employees. I was actually talking to a client yesterday about you know, what's going in the potential changes, and a lot of it, I just have this song in the back of my mind, which is, you know, anything you can do, I can do better. And I think this is kind of a good example of that line in that song in practice, really. So as we know, we saw in April increased rights for pregnant employees and also employees on maternity leave and adoption leave and shared parental leave. And we saw that in relation to the rights to be offered suitable alternative employment if they are at risk of employment during pregnancy, maternity, shared parental leave and adoption leave, and for a period of time after they return from that leave. Obviously, just remembering there that for shared parental leave, it has to be for a period of 6 weeks continuous leave. So we saw that in April, didn't we? So we're kind of getting to grips with how that works in practice. Thinking about, obviously, auditing workforces, not, making sure that we comply with that requirement. Well, the proposal under Labour is to go that bit further, and not just in redundancy, but basically preventing employers from dismissing employees who are pregnant or women who have returned from maternity leave and for a period of 6 months after they return from maternity leave for any reason. So again, huge extension here. Yes, there will be some exceptions to that, but again, we don't know what those exceptional circumstances might be. So protection there is going to be increased for women who are pregnant, and then for employees who are returning from maternity leave, and again for a period of 6 months. Whether that will be extended to adoption leave, I would be quite surprised if it wasn't, because we do find, don't we, that maternity and adoption sort of follow hand in hand. But certainly at the moment, if you look at the Labour's plans on making work pay, certainly it talks about increasing the protection for women rather than parents on adoption leave. For many of you, you are again getting to grips with flexible working. As we know from April, flexible working has become a day one right for employees, which basically means that employees can come to you on the first day of their employment and say, actually, that job that you employed me for when you employed me to work full time, that doesn't work for me. I'd like to make a statutory flexible working request to work flexible hours, please. So we're getting to grips with that, aren't we? What Labour proposes to do, again, is kind of, I can do better, is actually looking at reviewing flexible working and making it such that flexible working becomes the default position, unless employers can, justify as to why the job can't be worked in a flexible way. Again, I can see, issues arising over this default position. So how does this impact upon our recruitment processes? What does this mean? What are the exceptional circumstances? As we know, we have those 8 statutory grounds, don't we, to refuse a statutory flexible working request. Does that mean now that they are pretty much redundant? How are employers going to be able to justify saying, a job is advertised as full-time, it is full-time, if we're going to kind of have the default position is that every job can be worked in a flexible way? So again, one to watch, but I do think it's one to start thinking about now and having those conversations, with managers around flexible working, because there is going to be an expectation that employers are going to have to be even more flexible. And for those of you who've maybe caught the news yesterday, there is going to be there has been a greater number of businesses who are trialing the 4-day working week, and the narrative is that this current government will be more open to having discussions around the 4-day working week. So again, watch this space. I can see this becoming more and more of an issue, flexible working, but also what does a 4-day working week look like? What might it mean? 4 days a week for the same amount of pay. I think just watch this space on that, and read up on the consultations and get involved in the discussion. Parental leave, as we know, parental leave is that unpaid leave that employees have the right to after 1 year's service. It is unpaid leave that employees there are entitled to. The proposal there is to turn parental leave again, as we see with other family rights, don't we, into becoming a day one right. So employees having that right to take parental leave as of the first day of employment. What does that mean? Well, the leave is unpaid, of course. Also, the Labour government have sort of vowed to review parental leave, again, within its first year in office. So maybe we might see some sort of paid parental leave. We'll have to wait and see what that looks like. But certainly, you know, it is another right that HR and managers are going to have to be aware of when employees are making requests, you know, whether that's tagging it on to another form of statutory leave, or whether that's going to be somebody wishing to take unpaid parental leave in its own right. So again, it's more awareness, it's more making sure that our policies are up to date and publicised and people know what their rights are. Again, we saw, didn't we, the introduction of carers leave from this April, and that's that right for employees to take up to 5 days of unpaid leave per year to provide care for a dependent who has a long-term health condition. And again, we saw, didn't we, and we've updated our policies to make sure that that is a pro rata right. So employees who work part-time, again, that will be prorated as per their working week. What changes might we have? Well, potentially their paid carers leave. And I think that will be the statutory pay, so the pay that we already pay for maternity, adoption leave, etc., etc. So perhaps there's some changes. I've always talked about carers leave as perhaps that opportunity that businesses want to consider if they're thinking about, you know, improving employee, you know, the benefits that they offer. So maybe something to have a think about there. We do have parental bereavement leave already on the statute books, but this is looking at bringing the statutory right to take time off for bereavement more generally. So again, we'll have to look at what that looks like. And Labour also vowed to do away with unpaid internships. So again, something to think about there, particularly if you're offering, you know, work experience internships, etc., to potential employees there. So something to think about. So what else could we potentially see? Well, we've got some potential changes to the way the national minimum wage and the national living wage is administered. So the Low Pay Commission, as we know, makes recommendations as to how much they think the national minimum wage and the national living wage, how much that is. Labour is proposing to do away with, to remove that 18 to 20 age bracket. As we know, under the previous government, that right to receive the national living wage was decreased from age 23 to age 21. So what we will effectively have is every you know, worker over the age 18 and above, they're being able to receive the national living wage. So again, that's going to be a lot of number crunching for our finance teams. What does that look like? Again, you know, particularly where we engage our casual workers. So thinking there about, you know, the costs to the business, not just wages, but obviously the additional costs that go on top of that, pension costs, national insurance, etc., etc. So I think that that's going to have an impact from employers' perspective. So again, it's worth having a look at that now and getting to grips with what that might mean in terms of costs to your business. This is something that I talk about in the Manager Masterclass and also in the HR Masterclass. Who is working for you? What are they called and why is it important? So as we know at the moment, we've effectively got sort of 3 categories of employment status. We have an employee, we have somebody who is self-employed under a contract on the services, so they provide their services to a client, and then we have this sort of catch-all. We're not quite sure what they are. They're not really an employee. They're not really self-employed. They sort of control what they do, but they also have to abide by the rules, regulations, etc., that the client insists upon. And we've seen that, haven't we, particularly with the rise of the gig economy. You know, we all remember the Uber cases, Pimlico Plumber, Addison Lee, Deliveroo, we can go on. And yes, it causes some confusion, doesn't it, when we're thinking about, okay, what rights come? Because again, that's one of the key things, isn't it? Not just how much tax somebody has to pay, but what rights does somebody have? And that varies, doesn't it, whether someone is an employee, a worker, or genuinely self-employed. Again, we'll have to wait and see what this looks like, but Labour is proposing to have a sort of a single source of employee worker and somebody who is genuinely self-employed. Now, what does that mean in terms of rights? Does it mean that we're going to have a much wider pool of individuals who are going to be entitled to a day one right not to be unfairly dismissed? Are we going to have, you know, much more, you know, in terms of statutory pay entitlements and things around that nature? So that could have, again, a huge bearing, not just in terms of potential litigation, but also kind of costs as well. Also, for the genuinely self-employed, they will also be given new rights, and those rights include the right to be given a written contract and also protections there around payment terms, particularly around late payment. So I think this is going to have a huge impact. And again, a lot of the rights that we see for employees, there is a potential there that is going to be extended to workers. So I think something to watch out for as we move forward. This is what I think we're going to have to wait and see what it looks like. My concern with this sort of change is it again potentially opens up more litigation. What we have at the moment, as you will know, we've got those sort of thresholds when it comes to collective redundancy consultation, don't we? And that's set out in legislation where we're looking at the possible numbers of potential redundancies within an establishment. And as you know, we have had many, many years of litigation, particularly around the Woolworths case, looking at what is and what is not an establishment for the purposes of collective consultation legislation. And as we know, if we've got there sort of 20 or more proposed redundancies at one establishment within 90 days, we're looking at a 30-day consultation period, and again 100 plus within 90 days, we're looking at 45 days collective consultation before redundancies can take effect. So that's kind of where we are at the moment. Yes, we do have issues over what is an establishment. Is a place of work genuinely an establishment, or do we have to take the businesses as a whole? And it seems that the Labour plans regards to redundancy consultation tend to take a more kind of holistic approach to, you know, what is or what is not an establishment. So looking at the implication of redundancies or proposed redundancies across the whole workforce, impact on the business overall, rather than just, you know, actual numbers at an establishment. So I think there could be some changes here. Maybe the thresholds will stay, but I do think there's going to be some, you know, looking at how the impact on people, your people across the whole workforce, and maybe having different triggers, which I can see, again, you know, great work for lawyers, but perhaps not so great for businesses who are trying to manage these processes. So I can see more litigation around when, if collective consultation should have been brought in. So again, something there to watch and be mindful of. I just said, didn't I, that we're going to see the employee worker, you know, are they, aren't they, discussion, you know, perhaps simplified in some respects by having a single source of employment status. And again, what that means in terms of rights, because we know employee, gold standard, etc., etc. But what we are going to see is some changes to statutory sick pay. That is going to be available to not just employees, but to workers, so an extension there. Also extended such that it is available from the first day of absence, not day 4. As we know, we have those waiting days. And again, the removal of the lower earnings limit, which will again bring more individuals within the scope of being able to be paid statutory sick pay, the inclusion of workers, and again, it being, a day 1 payment applicable, day 1 of sickness, not day 4. So again, some changes there to expect. And I think these are the sorts of changes which will come in more quickly than others, because they're a little bit like, low-hanging fruit there. We'll see some changes to the apprenticeship levy. We will also see maybe sort of a little bit fudged ban on 0 hours contracts. As you know, that's been a big discussion point from Labour for a number of years now. Yes, there will be a ban on what is dubbed an exploitative 0 hour contract, but 0 hours contracts will be allowed in certain circumstances. But again, we don't know at the moment what those in certain circumstances will be. So yes, exploitative, what does that mean? And there are some exceptions to that. Perhaps no surprise, there will be increased powers in relation to trade unions. This is going to be quite important because there is going to be a change to rules relating to contracts of employment. And so there will be an obligation on employers to set out in its terms that employees have the right to join a trade union. So a kind of a proactive duty on employers, not just to put it in employment documentation, but also to regularly remind employees that they do have the right to join a union. So some changes there. Also, there's going to be some changes to the way that ballots are done, allowing electronic ballots to be made, and some changes around the voting process. And as you will remember, there was legislation passed last year looking at certain sectors, particularly around medical, so ambulance drivers, fire, other sort of core services, where essentially there was a minimum service level that needed to be provided in certain sectors. That's going to be repealed. So watch this space. TUPE, everyone's favourite, transfer of undertakings, protection of employment regulations. Looking here at potentially greater protection for employees, which obviously the flip side of that is less ability for employers to make changes in a TUPE situation. So again, maybe some greater protection there in terms of dismissal protections, and maybe greater protection there in terms of wanting to change and update terms and conditions of employment, which we already have, of course. We have that ETO, economic, technical, organisational reason. But again, I think there's going to be some tightening up of what that looks like. So again, watch this space. And there's more proposed. And I think, really, this is where we find ourselves in this situation where we do have legislation which is on the books. It has passed, but it's not yet in force. So what is that going to look like? So the first one I want to mention is around the rules about sexual harassment. Now, we know that there was going to be new laws coming in the autumn looking at sexual harassment in particular. And what there was lots of talk, and again, I've spoken a lot about this, written a lot about this, and the passage of this piece as legislation through Parliament has not been an easy one. There was a watering down of the obligations that went from employers will take all reasonable steps to prevent sexual harassment in the workplace. That was watered down to employers will take reasonable steps. So the removal of that word all. The other change that we saw prior to the legislation being passed was in relation to third-party harassment. And there was lots of concern raised, particularly for employers in the hospitality sector and the leisure sector, saying, look, you know, we aren't there to police the speech of our customers and our clients. Yes, you know, we take steps and we train our people, and, you know, but we're not there to sort of stop people having conversations. So that third party reference was actually removed from the legislation that was passed. Obviously, fast forward to July 2024, and we see a new proposal that has been, you know, pledged, that actually we will revert back to employers having to take all reasonable steps. So again, really pushing that threshold much higher for employers, and also the reinstatement of the prevention of third-party harassment. And again, we have seen the Equality and Human Rights Commission, so the EHRC, they have published some guidance on preventing sexual harassment in the workplace. And that has come out this week, which talks about all reasonable steps and preventing third-party harassment. So I think all of that lobbying, all of those changes, I think have obviously will be removed, and we will go back to what the legislation was in its form when it was brought before Parliament. So I can see some changes with that one. The other point to note is that women who raise issues of sexual harassment at work will get quasi-protection, as we see with whistleblowing, so, you know, prevention of you know, less favourable treatment, detrimental treatment, and obviously dismissal. So again, an enhancement there of the rights of women who raise allegations of sexual harassment. Whistleblowing more generally, where workers, employees raise concerns about workplace practices which they in the public interest that are illegal, dangerous, and so on. Again, that is one that is going to be reviewed, and there is talk that protections for whistleblowers will be enhanced. Predictive working, predictable working hours, stability, security, these are all, you know, kind of buzzwords. We did see legislation passed again that would come in the autumn, which would give individuals, you know, workers, the right after 26 weeks of work with a particular employer, that right to be able to ask for more predictable working hours, more stability. And again, corresponding rights that we see with flexible working as to why the employer cannot provide more stable working hours. Labour have decided that they want to take that one stage further. Again, what that means for the legislation coming through, probably it means that it's going to be put on ice, but certainly looking at that predicted rights. So again, employees, workers who do work flexible hours, who do have variable hours, they're being able to ask that there is using the 12-week reference period, again, to have greater say, greater set hours in terms of what they work, and also proportionate compensation payable if shifts are cancelled or curtailed unreasonably. Again, a methodology there for workers to be compensated should that happen to them. So again, taking what we've currently got on the statute books, but again, increasing that level of protection. So watch this space on that current piece of legislation. Fire and rehire, again, this is one area that I feel I've been talking about for a long time. Again, some greater scope there. As you know, at the moment, we have the previous government wanted to go through a consultative route, so using ACAS to draw up a code of practice as to how employers should approach hiring, firing and rehiring. So fire and rehire looks at where an employer seeks to end an employee's current work under their current contract, so giving them notice under their current contract, and then before that notice expires, giving the employee a new contract of employment, which is typically on less favourable terms. So again, fire and rehire. What the proposal is there is basically the ACAS code is not enough. We need legislation on this. Obviously, that's going to take some time. So I think this is another piece of legislation that will be put on ice. So again, let's just wait and see what that looks like and whether we do see legislation or a more strengthened code of conduct around fire and rehire. Tips. Again, this is one where we are awaiting confirmation as to what's going to happen in the autumn. I know businesses have taken a lot of time and a lot of trouble to, consult with staff, get plans in place. What the Labour plans talk about is allowing workers to decide how tips are allocated, which sort of suggests, doesn't it, that there will be some changes to what is proposed. Certainly, at the moment, the way the current legislation is drafted, it is for employers to take the tips that are in its control and then allocate those. But this is putting greater say on workers and being able to say, well, we think it should be split, whatever percentage terms. So again, I can see some changes there being made. And again, that doesn't help businesses who are, seeking to kind of, put plans in place from the dates that we were told that legislation was going to come into play. Other changes as well, just to mention, the right for individuals to be able to bring collective grievances through ACAS. That is going to be a change there. Some changes as well in the field of protected characteristics, looking at bringing in dual characteristics. So, for example, an older woman being able to bring a claim on sex and age. So dual characteristics there. And the other change, and something to think about, is the right to disconnect, the right to switch off. And this is something that has been proposed. So again, not to be contacted outside of work by your employer. Looking at the Belgium and the Irish model. So if you want to go away and have a look about what that might look like, so go and Google the Irish and Belgium approach to switching off. But essentially what it means is that workforces and employers will come together in a meaningful consultation and decide what a right to switch off would look like for their businesses, and drawing up policies and maybe contractual terms as well. So again, looking at things in a workforce agreement type way. The numbers joining me today have been amazing. Thank you so much. There is a lot to take in, and I do think this is one that we're going to be talking about for a while. What can we do now, and when might this happen? Well, we've been told, haven't we, the first 100 days. I don't know, and again, please tell me, for those of you who are more politically switched on, how the first 100 days works with obviously the summer recess that we have coming up in Parliament, whether that's actual working days or actual days that the government have been in power, because that's not a long period of time if it does include the amount of time that is in the summer recess. If we are going to see changes, it's not going to be for another 6 to 12 months. But again, there could be quite a lot happening, as we've seen, quite quickly, as I do think there is a bit of, low-hanging fruit there that can be changed, parental leave being one of them, paid carers leave. They are things that can be done relatively swiftly. We are also going to see a new enforcement body introduce, a new employment police force, which is going to be the Fair Work Agency, and they're going to have some rights there to be able to take enforcement action against employers, particularly around worker exploitation, national minimum wage, health and safety, and other areas as well. So we've got, and they will have the ability to be able to take claims, as we see, don't we, with the Equality and Human Rights Commission as well. So they will have new enforcement powers. We're also going to see greater enforcement powers from the Employment Tribunal as well as digitising the Employment Tribunal service. So again, some changes there in terms of enforcement, and greater bodies having greater power. What advice can I give you now? What tips? We're going to have to look, aren't we, at our onboarding processes and our probation periods, particularly if and when the day one right comes in. So that's going to be something we need to look at. We're going to need to train our managers, aren't we, particularly on the legal training around sexual harassment, preventing harassment. What does all reasonable steps look like? What do we do if something is raised? And also thinking about third-party harassment as well. So again, legal training, get involved, contact me. It's, relatively straightforward to run some training for your managers, but it's going to be very, very important, because this is a preventative duty. It's not reactive. What all reasonable steps did you take to prevent sexual harassment within your workplace? And being able to stand up and say, we have taken all reasonable steps. What else are we going to have to do? I think we're going to have to do a lot of auditing, aren't we? We're going to have to audit, firstly, how many people do we have within our organisation? When we think about those reporting obligations, we are going to have to think about our outsourced workers. Obviously, what and who is an outsourced worker, and how does that implement and impact upon our numbers? So we're going to have to do some auditing. We're going to have to look at things around pay, aren't we? If pay is going to change, statutory sick pay, greater rights for workers to be entitled to certain payments, what is that going to look like for us, and what's the bill going to be for payroll, national minimum wage, national living wage? And we're also going to have to look at our policies and processes, aren't we, in greater detail, greater scrutiny. And again, that's another area where we can assist you on. So again, do get in touch. There's my email address. Please do reach out. I will be getting in touch with you all in terms of what you can do to stay up to date. I think getting in, signing up for our newsletters, signing up for our webinars is going to be one way that you can get in touch. I think the other way is to kind of sign up for training, particularly manager training, particularly HR updates. So again, get in touch with me if that's something that's of interest to you. And, I think it's just being aware of what's going on and how these changes, will affect what you do. I think it is genuinely going to put more pressure on HR teams, some of which, are small, particularly when we think about the 3 to 6 months, perhaps the increase there in data subject access requests. We can help with that as well. We can manage, and we do manage DSARs on behalf of clients. So there are lots of ways in which we can all help each other. So that brings me to the end of the webinar. Again, the numbers have been amazing. Thank you so much. And if this is the first time that you've joined one of our webinars, then please do sign up for the webinar at the end of the month. We do run these monthly, and save for the month of August. But again, great ways to kind of join the discussion, get involved, and also, be part of the HR community, which I know is really important. So I do thank all of you for joining today. And thank you so much for all the lovely comments that are coming through as well. That is so lovely. Thank you so much. Yeah, I'm here to help you kind of stay in touch, get your managers trained, and get your HR teams up to date. So please do stay in touch. Enjoy the rest of your days. If you're watching this on demand, thank you so much. And let's keep in touch. It's going to be a bit of a roller coaster, isn't it? But we are all in it together. And I will speak to you and hopefully see you all soon. Thank you very much indeed. Goodbye.